Um, yep. Okay. Welcome, everyone. Tonight is the first of a series of programs that will be held on the third Thursday of every month, hosted by the League of Women Voters of Wheaton and Professor Steve Schwinn of the University of Illinois Law School. This series of programs, Foundations to Front Pages, is designed to help us become more informed and engaged citizens by deepening our understanding of what the Constitution actually says and how it is being applied, challenged, and interpreted in real time. By connecting today's news to our constitutional foundations, we can better evaluate public debates, understand judicial decisions, and participate thoughtfully in our democracy. Please submit any questions you may have during Professor Schwinn's presentation in the chat, and he'll try and answer as many as he can before our time together ends. So, without further ado, it is my great honor and pleasure to introduce my friend and turn the program over to him. Professor Schwinn?
Barb, thank you very much. Barb and Chris, thank you for hosting and organizing this Zoom, and thank you for all of you for attending. This really is a great honor and pleasure. I just want to say a quick word about when Barb first contacted me about doing a program like this. I think we both were really, really excited about it and thinking about all the different possibilities with all the different issues that we're reading about in the news every single day, trying to unpack them and sort of figure out constitutionally what's going on. What does this mean for us as participants in our democracy? And what can we do about all this if we're inclined to do anything about it? And so we sat down and kind of brainstormed some different topics and thought, how are we going to organize this thing over the course of the months that we're going to work together. And what we thought is we would dedicate each week or each month, each session, I guess, to a particular topic and do it topically or thematically. And as we do that, kind of touch on different issues that are both in the news and the politics, but also in the Constitution, and sort of unpack them and see what we can do. And, as I was thinking forward to tonight, it really is going to be just a whirlwind constitutional lesson. So buckle up. I hope you're all ready for it. We're going to have a good time tonight. What we thought we'd talk about is immigration enforcement, and particularly ICE enforcement and things that we're seeing out of Minneapolis, things that we've seen in Illinois. What can we, the people, do if we're concerned about immigration enforcement? What's the authority for immigration enforcement? Are there any limitations on it? And what are the alternatives to immigration enforcement through ICE or through Border Patrol or DHS or FBI or whatever agency is getting involved with immigration and enforcement? Um, you might have noticed just today, President Trump announced that he was considering invoking the Insurrection Act and and detailing military to Minneapolis and potentially other areas in the country. Let's talk about what that means. Does he have authority to do that? What's the significance of invoking the Insurrection Act as opposed to different statutory authority that he had previously used to detail the National Guard to cities like Chicago? And what does all this mean? Um, when I think about constitutional law, what I love about it, I love a lot of stuff about it, but a couple of things I really love about it is that it's like, it's like opening up the hood of your car and trying to tinker around and figure out how the engine works, right? We all know how to drive a car. We all know how to be citizens in a democracy, but let's figure out how it really works. Let's get under that hood and start to take things apart and figure out how that thing operates. That's what constitutional law is all about. How public policy, how politics, how they work. What's the system that we have for them working? Another thing I love about constitutional law is that it's constantly changing. It's just always in motion from day to day, from these days, from hour to hour. We're getting new constitutional issues that we need to address, and they're critically important, and they're novel. These days, everything is new and novel and different. We just haven't seen this stuff before at this kind of scale and at this kind of pace. Very exciting time to be alive for many, for me, a terrifying time to be alive, but also a time full of opportunity for civic engagement and civic discussions just like this. And then finally, what I really love about constitutional law is it gives us an opportunity to engage in these kinds of discussions, just like we're going to have tonight. And we are, we're on Zoom. We're not in person. I don't see you. I know you see me. I do see your participation in chat, and I'll be grateful for your questions and comments as we go along tonight. But nevertheless, this is an important civic discussion. This is what democracy is all about, in my view. We all know how to vote. We all know how to use our voice to speak. We all know how to petition our representatives. We all know how to organize, and those things are really important too. In my mind, civic discussion like this is really what inspires us as small d democratic citizens. It certainly inspires me. I was talking to Barb and Chris a little bit before this. As a teacher, I get really energized by my students. They excite me, they inspire me, they are the ones that keep me doing what I do on a day-to-day basis. And I'll say that similarly for groups like this. You all keep me energized and engaged and excited. And I got to tell you, I'm just blown away that Barb was able to organize this with as many people and as much interest as there is. So I'm really, really honored to be with you. It's a true, true pleasure and just such a thrill. And so we're going to spend the next almost an hour talking about immigration enforcement. And before we get going, I kind of framed this out. I said, let's talk about immigration enforcement, what's going on in Minneapolis, what we've seen in Chicago, what we've seen in Portland, LA, other areas of the country. Um, I've got some things that I think I'd like to share with you tonight about what we're seeing out of Minneapolis and what's now going on in Minnesota and Illinois with their lawsuits against ICE. But I'm also curious to hear what you're interested in. This is not really going to be any worth anybody's time if I just sit here and chat about what I'm interested in. I'd really rather hear what you're interested in. So let's just take a second. We're just going to pause. I'm going to stop talking here for a minute. And if you wouldn't mind just dropping in chat some things, some topics around immigration enforcement that you'd like me to touch on tonight so that I can be sure to address what's important to you, not just what's important to me. All right, everybody, thank you. Okay, I am not seeing a lot in chat. Um, Deployment of the National Guard. Good. Thank you, Sue. What can I do for people in my community beyond marches? Really important question. Absolutely. Immigrant rights. What can we do about all this? How it relates to the Constitution. Good, good, good. The legalities and consequences of the Insurrection Act, a really important question. Um, no efforts for immigration reform. Yeah, great question. Without a warrant. Okay, good. Due process, how to enforce. Okay, good, good, good. Local police, yeah, ignoring the.
So, Steve, I see a question.
Yeah,
Can local
good.
police arrest federal
Yeah,
employees they
yeah,
believe committed a crime?
yeah, yeah. We'll definitely talk about that. I want to talk about immunities and responsibility and liability that federal officials have for some of the behavior that we've been seeing.
How can volunteers stay safe while they're trying to help immigrants?
Yeah,
Limits are there on ICE?
yeah. These are all great, great questions. Really good questions.
Can
Um,
I just ask a question too about the ability of the executive branch to use funds that have been allocated in the budget to other branches, the distribution of funds and not as designated by the legislature?
yeah, for sure. I am going to, yes, thank you, Barb. Absolutely. I'm going to try to address as many of these as we can. Um, for ICE agent who killed Renee. Yeah, yeah. And I think maybe actually, I think in some ways, kind of that last question, talking about the shooting last week, Renee Good's shooting, um, and what's going on with that? What's the legal liability? Some of you may have seen on the news, Tony Romanucci here in Chicago, a famous civil rights attorney, has been representing the Good family and is looking at legal options here. It turns out it's a kind of complicated picture, and I'd like to walk you through it so that you can see where the roadblocks are to bringing a claim against the officer who shot Renee Good and bringing some liability and responsibility and some relief to Renee Good's family. Yeah, yeah, these are all really, really good questions. Thank you, everybody. Lorraine, Mark, thank you, Marilyn, Ellen, Lisa, everybody who's asked a question. I do really appreciate it. And again, I'm going to try to get to as much of this as we can tonight. Um, if I don't get to your question, and or alternatively, if you want to follow up with me outside of this session, feel free, drop me an email. I'm at Schwinn, Schwinn, at UIC, as in University of Illinois, Chicago, Schwinn at uic.edu, and I'd be happy to engage with you outside of this session. So let's start here with regard to what's going on in Minneapolis and ICE enforcement in Minneapolis and the Renee Good shooting last week. So we're going to start with a very basic principle in constitutional law, and that is that we have a government of limited and identified, defined power. And what that means is any government actor has to be able to find a source for their authority in the Constitution. That even includes the president. The president and any member of the executive branch, anybody in Congress, even judges on the court, before they do anything, they have to have authority to do it. Now, for the president to do something and therefore to order, for example, Kristi Noem or other executive officers to do something like ICE enforcement, they have to have authority. That authority comes either from the Constitution or more likely from a statute enacted by Congress. And so when the president orders ICE agents out onto the streets in a city like Minneapolis, or Chicago or whatever city it is, the president needs to have statutory authority to put those ICE officers out on the street and direct them to enforce immigration law. Now, there is authority, as it turns out, for the president to do that. That authority is going to be somewhat limited by the amount of money that Congress has allocated for ICE enforcement. And Barb, you had asked about what about taking money from other appropriations and using it for ICE enforcement? As a general matter of appropriations law and separation of powers, the president can't do that. The president can't take money from the military budget, for example, and direct it to ICE enforcement. The president is bound by the appropriation that Congress has passed, and including the particular line item of the appropriation that Congress has passed. What we say in constitutional law is that Congress has the so-called power of the purse, the power of appropriation, the power of spending, and that includes the power to direct how that spending is going to be spent by the president. And the president can't really deviate from that unless Congress allows the president to do so. And so if Congress has allocated such and such amount of money for ICE enforcement, the president really is limited by such and such amount of money for ICE enforcement and can't draw on other pots in order to augment or supplement that appropriation. That said, Congress has given the president a lot of funds for ICE enforcement, and we've seen the administration move rapidly to hire new ICE officials, new ICE agents, and train them very, very quickly and get them out on the street, which I think may be part of the problem that we're seeing with ICE enforcement in a place like Minneapolis. So if the president has enforcement authority, and the president does in this case, to the limit that Congress has appropriated funds, then on the backside, we want to ask, are there limits on the president's authority to use ICE agents to enforce immigration law? And a number of you have asked questions about free speech, warrants, Fourth Amendment issues, and the like. And there are limits on ICE agents' ability to enforce the law. Those are primarily in our Bill of Rights, the first 8 amendments to the Constitution. And so we, the people, do have free speech rights. We, the people, do have due process rights. We have all the rights in the first 8 amendments to the Constitution. And those things bind and restrict the way that ICE agents are able to enforce the law. So here I'm just going to say really quickly, we've seen late last year a district court in the Northern District of Illinois issue a very lengthy opinion detailing different activities of ICE agents here in Chicago. The opinion runs over 100 pages and details with great specificity all the abuses that we saw by ICE agents here in Chicago, all the violations of free speech against ordinary citizens like you and me, but also against the press, violations of the Fourth Amendment, violations of religious liberties, all kinds of different things that ICE agents were violating. And so we are seeing some judicial pushback in some instances to ICE agent overreach based on individual rights violations. And at this point, what I want to do, having set up that broad construct, first we're going to look to the authority that the president or the executive agency, in this case ICE, has to do what it's doing, right? And we've effectively answered the question, yes, they do have authority subject to the funding restraints that Congress has imposed. And then on the back end, we want to ask what kinds of restrictions are there on that authority? Well, they're restricted by the First Amendment. They can't violate free speech or free exercise of religion. They're restricted by the Fifth Amendment, due process. They're restricted by equal protection principles that we've read into the due process clause. And so we've got this broad construct. And now what we want to do, I think, is kind of drill down to figure out what happens when an ICE agent or the ICE agents together start to violate those back end restrictions. And so we're going to kind of get into the weeds here, but I think they're important weeds for us to understand what's going on. They're also important weeds because if we understand this at a very particular level, we can also understand how the law is working in favor of ICE agents and against ordinary citizens and ordinary people in the United States who might be subject to ICE enforcement, and think about how we can start to instigate for change in that kind of law. So let's use the good shooting last week as kind of a focal point for this portion of the discussion. When an ICE agent shoots good last week, as he did, he may violate a number of different laws, and he might violate the Constitution. He might violate due process, for example, in shooting her and taking life, liberty, or property without due process of law. And so then we start to wonder, okay, so for somebody like Good or her family, what kind of recourse does she have to hold the officer to account, to hold the government to account for that behavior, and to compensate the family for the very significant and really, really priceless and uncompensatable injury that they have suffered? You really can't compensate for a death, but to the extent that they can seek some sort of compensatory relief, what might be available to them. Here's where things start to get a little tricky. So I'd mentioned earlier that the Good family has contacted the Romanucci law firm. They're going to represent her and presumably file a civil action against the officer and against ICE and anybody who had any responsibility over this matter whatsoever. Ordinarily, when a person files a claim against a federal actor for what we call a tort, a personal injury, and in this case, it's a significant personal injury, it's a death. We call it a constitutional tort because it has a constitutional dimension to it. Here, a violation of due process, that the agent took her life without due process of law. And so, ordinarily, when somebody is injured in that way by the government, what would ordinarily happen is you would file a claim against the government under what's called the Federal Tort Claims Act. This is an act enacted by Congress that says, effectively, we understand the government as an undifferentiated whole. Government and its officers from time to time are going to do things that injure people. And we understand that those people who are injured ought to be able to get some form of relief for that injury. And so they can file a claim under the Federal Tort Claims Act to seek a relief for a tort or an injury that the government or a government actor or agent meted upon them. Um, and at this point, I should mention that the reason that there's a Federal Tort Claims Act is because the federal government enjoys sovereign immunity from a lawsuit. And what that means is we ordinarily can't just march into court and sue the federal government for monetary damages. It doesn't work that way. The federal government has sovereign immunity from those kinds of suits. And in order to sue the federal government, we would have to look for what we call a waiver of sovereign immunity. And so this Federal Tort Claims Act operates as a government's waiver of sovereign immunity to allow individuals to file claims against the government for compensatory damages under certain circumstances. And so that would ordinarily be what happens. The problem with the FTCA, the Federal Tort Claims Act, is that there's a long, long process before you can file a claim, and the agency can reject your claim. And if they do, then you can go to federal court, but then that's a whole new stage of process. And the relief that you can get under the Federal Tort Claims Act is not always complete relief, depending on the kind of injury that a person incurred. And so the Federal Tort Claims Act may not be the best option for somebody like Good or her family who's seeking relief and accountability on the part of the officer. Now, if the Good family were to sue the officer, which I expect that they probably will, then another federal law called the Westfall Act. The Westfall Act means that the government will automatically step in and take over the defense of that case and treat the case effectively as a Federal Tort Claims Act case. And so the individual officer isn't going to be liable under this kind of construct. It would be the government as a whole. And again, a plaintiff in that kind of case, in this case, the Good family, is going to be restricted in the kind of relief that they might be able to get because of the lengthy process that the FTCA requires, first going to an agency and requesting relief, and then filing in federal court if a person is denied, and the extent and type of relief that a person is allowed to receive. And so this whole sort of FTCA, the Westfall construct, that ordinary kind of construct, probably is not going to be great for somebody like Good or her family. Um, and as it turns out, there's some good news here. And that is that there is an exception to the Federal Tort Claims Act for exactly what I had mentioned before, this kind of constitutional tort, that a person can, at least in theory, sue a federal officer for a constitutional tort. Now, I want to pause here for a second and give you some background information on this because I want to kind of contextualize it for you and help you understand the limitations on federal officer liability for a constitutional tort. And so I'm going to take a kind of a sharp turn here. Consider this sort of a footnote to this discussion. And what I want to talk about is not federal responsibility for a constitutional tort, but instead state officer responsibility for a constitutional tort. It turns out that you and I can sue a state officer for a constitutional tort in state or federal court under a federal statute at 42, Title 42, United States Code, Section 1983. Now, I'm that specific about it because Section 1983 is the bread and butter of civil rights attorneys. That's what we use all the time when we're suing state officers for constitutional violations. We seek compensatory damages under Section 1983, and other civil rights statutes allow us to get attorney's fees and in some cases even punitive damages. So that's kind of the bread and butter if we're suing a state officer like Chicago City Police, for example, or Illinois State Police. But what about federal officers? Is there a statutory hook or statutory authority for you and me to sue a federal officer for a constitutional violation? It turns out there's not. There isn't that kind of hook. There is a case from the Supreme Court going back to the 1970s. In 1971, the Supreme Court ruled in a case called Bivens, Bivens, versus six unnamed FBI agents. We just call it Bivens. There is a kind of court-made relief that an individual can file against a federal officer. But the problem is, in recent years and decades, the Supreme Court has so narrowed this Bivens remedy that it barely exists today. It's extraordinarily difficult to file a Bivens claim against a federal officer today because of the way the Supreme Court has narrowed that doctrine. Now, I'm giving you a ton of information right now that's at a very particular level of detail. And as I said a few minutes ago, part of the reason that I'm giving you this information is because I want you to know it and be an informed citizen, but also because this is an opportunity for us to think about how we can change the law, right? Remember, I said Congress did enact a law, Section 1983, that would allow us to sue a state officer for a constitutional tort. Congress has not enacted a parallel law to sue a federal officer for a constitutional tort. There's Bivens, but it all but doesn't exist. There's the Federal Tort Claims Act, but that's not really going to get us anywhere and probably not provide full relief. And so, what do you have if you want to sue a federal officer? Well, here's a point where we can instigate. If you think that federal officers ought to have some sort of liability for constitutional torts, call your member of Congress and get them to enact a federal 1983, a 1983 Bivens statute so that it's on the books and we can file against federal officers for monetary damages, right? Understanding the problem at that level of detail gives us a really concrete idea for moving forward. Legislation at the federal level that would authorize a civil rights suit against a federal officer for monetary damages. It really is quite simple. The politics are much more difficult, obviously, but the solution is pretty simple. Okay, so let's assume that Good and represented by Romanucci, the Good family is actually able to overcome these barriers and get into federal court and file something like a Bivens claim against the officer who shot Good and seek monetary damages as a form of relief. Well, at that point, there's another problem. The problem is, maybe this is a phrase you've heard before, qualified immunity. The officer is going to assert qualified immunity. Qualified immunity is think of it as kind of a pseudo constitutional um, doctrine. And what I mean by that is there's nothing in the text of the Constitution that offers qualified immunity to an officer in these circumstances. There are a lot of different immunities in the Constitution, but this is not one of them for officers in these circumstances. Instead, the Supreme Court made up this idea of qualified immunity as a kind of constitutional-ish type doctrine. And what I mean by that is the Supreme Court relied on kind of constitutional thinking and a kind of constitutional logic to arrive at this doctrine of qualified immunity. What the Supreme Court said is if federal and state officers don't have some sort of qualified immunity, what that means is people are going to sue them all the time, and they're then going to become really shy and cautious in the way that they enforce the law. Now, what the court says is we don't want that. We want them to feel empowered to enforce the law. If they feel like they might be legally vulnerable when they go out and enforce the law, that's going to be a problem. And so the Supreme Court invented this idea of qualified immunity. Here's how it works. If you sue an officer, state or federal, but here we're talking about a federal officer, they can assert this idea of qualified immunity and say, I'm actually immune from suit unless a plaintiff can show that there was a clearly established constitutional right that I violated, a clearly established constitutional right that I violated. The problem with that doctrine is the Supreme Court has interpreted it in a way to really narrow this idea of clearly established constitutional right. The clearly established constitutional right has to be a right under the particular circumstances of the violation. So, for example, in the Goods case, what the court would likely to be say is that there had to be a clearly established constitutional right of Good not to be shot when she was moving her vehicle as she was. There was an officer in the vicinity. The officer will undoubtedly express fear for being hit by the car. Is it a clearly established constitutional right that she has not to be shot in that circumstance? And and that's going to be a really hard thing for her to overcome. What she would have to do is point to a specific case that establishes that clearly established constitutional right. But of course, as many cases as there are out there, there's probably not a case that says there's a clearly established constitutional right in the precise circumstances that Good found herself on that fateful day. And so this is a huge barrier for plaintiffs in filing constitutional torts against any officers. But again, here we're talking about federal officers. And again, I'm giving you a lot of detail here because I want you to know, but also because this is a point of action. If we don't like qualified immunity, it turns out there's something we can do about it. We could petition our members of Congress and seek legislation to relax the qualified immunity standard and make it much, much easier for us to sue federal officers and hold them to account for the constitutional torts that they commit. So if we're in Romanucci's law firm or we're representing the Good family, we have a lot of barriers to overcome here. If we wanted to file a federal civil rights suit. And some of those barriers give us opportunities to think about civic and political action. Maybe we need a Bivens 1983 federal statute that allows us to sue federal officers for monetary damages. Maybe we need legislation that relaxes the standard for qualified immunity, right? And that might be moving us in the right direction. Um, there's a theory that's kind of percolating out there. I'm not quite sure where this is going to go. It's called a reverse 1983. And the theory says that a plaintiff like Good could sue an officer for a constitutional tort in state court under state law and hold them responsible in state court under state law. As it turns out, there's a long pedigree for this kind of claim. It goes all the way back to the founding, and indeed up until 1971, when the court came out with Bivens, this was the predominant way that we, the people, held federal officers responsible for constitutional torts and other legal violations. Sue them in state court under state law. And so there's a theory percolating out there that we could use this kind of what some are calling a reverse 1983 claim, a civil rights claim filed in state court under state law against the federal officer and get liability that way. The Supreme Court hasn't ruled squarely on that, whether that's an available remedy for plaintiffs at this point. And so we really don't know. As with so many things in the Trump administration these days, we really are in uncharted territory. But there's a lot of good scholarly work around that theory. We may see it tested soon, and so that's another point of potential access. The more that we can talk about and normalize this idea of a reverse 1983 claim for a legal violation in state court, the more that that becomes likely to become a thing when these claims start to be filed against ICE agents. All right, so I've given you like a tremendous mouthful. I'm going to take a break so I can stop listening to myself talk and see if you have any particular questions about the ton of information that I just dumped on you. And then what I want to do is pivot a little bit and talk about some other ways that we might be able to hold the officer and ICE in general responsible and liable, and ways that we might be able to get them to stop immigration enforcement, or at least temper it in cities like Minneapolis and Chicago.
Steve, we do have one question about aren't the current ICE raids and deployments in direct violation of the Constitution? And I think this kind of goes along with another question of how can Trump ignore the Constitution,
Yeah.
or how can he, are all these executive orders enforceable? And I think this all goes around the where's the legislature in all this? Where's Congress in all of this?
Let me address that real quick, Barb, because I think that's going to be a continuing theme in this series that we're going to constantly come back to. You know, our separation of powers system only works if the coordinate branches are willing to check a rogue branch. And here we undoubtedly have a rogue branch in this president. He is violating the Constitution and constitutional norms right and left almost every day. It's extraordinarily difficult even to keep up with. And the problem is the coordinate branches, Congress and the courts, are not checking him. Congress isn't checking him, I think, largely for political reasons. They're towing the line and supporting him politically. The courts aren't checking him for a variety of complicated reasons. Some people might say that the courts aren't checking him ultimately because the Supreme Court is actually skewing his direction politically, that the Supreme Court is kind of towing the line in the same way that Congress is. I think there may be some truth to that, but I also think what's happening at the Supreme Court is the court has been on kind of a long trajectory that's been going back years and decades before the first Trump administration that has been moving in the direction of Trump's vision of the Constitution, at least in some really important areas. And so, what seems to be happening, or in my view, what seems to be happening is the Supreme Court has kind of set the constitutional doctrine on a particular trend line. And that met the Trump presidency, which then accelerated that trend line. And so I actually see the Supreme Court and President Trump almost kind of working hand in hand to to create a kind of constitutional reality that's very, very different from what we've understood in the recent past. And I think that's part of the problem with the courts. And then finally, with the courts, you know, the courts aren't institutionally designed to keep up with a president who is moving this quickly. They're just not really good at moving fast and halting a president. And so we're seeing lower courts, the district courts and the appeals courts being much, much more aggressive in halting some of Trump's actions. But but ultimately, as these cases work their way up through the system, it takes time, and courts just are not institutionally designed to respond quickly to to really the fire hose of constitutional violations that we're seeing. And so, Barb, I think that's going to be a continuing theme as we work through this. And I'm really grateful for the opportunity to talk about that now. Um,
Sandra asks a question. Can you speak about the Illinois law that was just recently passed and signed into law by J.B. Pritzker that allows individuals some remedy if they feel their rights have been violated by law enforcement as it pertains to immigration raids?
yeah,
Not sure if I,
it's a good question. And Sandra, I don't want to misspeak. And so I'm going to need to do a little bit of research and make sure that I'm understanding the same law that you're talking about. But as a general matter, states are moving more and more, at least states that want to challenge ICE enforcement efforts and other things that the administration is doing. They're moving more and more to create different kinds of causes of action in the state courts to try to hold up the administration. It's a little bit, in some instances, it's a little bit like this reverse 1983 action that I described a few minutes ago. And so Illinois, I know, has been moving in that direction in some areas, and I just want to be sure that I don't speak out of turn and talk about something that you're not asking about. So I'm gonna ask your forgiveness and do a little hunting around on that, and we can come back to it the next time, or you can email me. But I suspect that what you're asking about, and I suspect that what's going on in Illinois is some kind of state law cause of action in the state courts that would allow Illinois residents to sue ICE or its officers or the administration for constitutional violations outside of that sort of limited framework that I described a few minutes ago, which I think is a good thing, and it's a role for the states in our system. And I want to talk about another one. Um, we haven't talked about criminal liability for the officer. There is potential state criminal liability for the officer. I don't expect there'd be any federal criminal liability that would be brought by the Department of Justice, which seems to answer directly to President Trump these days, which itself I think ought to be a subject of a future discussion. But I don't think we're going to see a federal criminal prosecution, but we very well may see a state criminal prosecution. And this implicates all kinds of really interesting federalism issues. If state prosecutors decided that they wanted to prosecute the officer for homicide, for example, they could bring charges, and at that point, I would expect what the officer would say is a couple of things. First off, I'm a federal officer. I can't be prosecuted by state authorities because the federal government is supreme over the states under the Supremacy Clause of the Constitution. And he would probably say what we've been hearing from Stephen Miller in recent days, that he enjoys a kind of absolute immunity from state prosecution because he's a federal officer. Well, he's going to claim that, but he turns out he's wrong. We do have a history and tradition in our country of federal officer responsibility for state criminal violations. What has to happen is a state prosecutor would have to show that a federal officer acted obviously illegally in violation of the law, but also with excessive force, went sort of beyond the scope of their duties in an unreasonable way. And if a state prosecutor were able to show that, then they could prosecute a federal official under state law. Now, that would be highly unusual, and it would raise all kinds of interesting and new federalism concerns. But ultimately, at the end of the day, the doctrine does allow a state prosecutor to prosecute a federal officer for violation of state law. Again, if the officer acted illegally with excessive force and unreasonably and outside of the scope of their duties. And so there may be some other ways outside of the civil system, the civil damages system, to hold this particular officer responsible. And then I think, I'm aware of the time. I do want to walk you through one more thing that's going on. What we're seeing in Minneapolis has inspired both the state of Minnesota and what we saw here in Chicago, the state of Illinois, to actually sue the federal government to stop ICE enforcement in Minneapolis and in Chicago. And this raises all kinds of really, really interesting constitutional issues as well. What the states are arguing is that the federal government is violating the 10th Amendment when it sends ICE officials into the cities to do the kind of aggressive enforcement that they're doing. And this is the way that works. What the states are arguing is the 10th Amendment, part of what the 10th Amendment says is that the federal government can't boss around the states in their sovereign capacity. The federal government can't tell states what to do in their sovereign capacity because states have independent sovereignty in our federalism system. The Supreme Court has called this the anti-commandeering principle, that the federal government can't commandeer the states in their sovereign capacity and can't commandeer state officers in their sovereign capacity. And so you might wonder, well, what in the world does this have to do with aggressive ICE enforcement in Minneapolis and Chicago? What the states are arguing is that because of the aggressive ICE enforcement, it's required the states to respond with increased law enforcement efforts, siphoned resources away from their ordinary law enforcement efforts in order to respond to problems that ICE is creating in those communities. And so, for example, they've referenced the number of 911 calls that they've had to respond to because ICE agents are in their communities, which means that they can't do their ordinary job. They have to respond to 911 calls that are created by ICE. And what they're arguing is that that's a kind of commandeering by the federal government, that the federal government has so overwhelmed Minneapolis. Remember, there are something like 3,000 ICE agents in Minneapolis. Minneapolis only has about 600 ordinary law enforcement police of its own. So they really are overwhelming the city and overwhelming the city's resources and requiring the city, in effect, to use its resources in ways that the city wouldn't otherwise use them. They're making another argument too, which I think is a really interesting one. It's what we call an equal state sovereignty argument. This is kind of a novel argument. We haven't really seen it except in a voting rights case that the Supreme Court ruled on in 2013 called Shelby County, a really important case that kind of revitalized and reoriented this idea of equal state sovereignty. Equal state sovereignty before 2013 meant that states, when they were admitted to the Union, had to be admitted to the Union on equal terms. That was what equal state sovereignty meant. In 2013, the Supreme Court kind of redefined it a little bit and referenced equal state sovereignty as a kind of equal treatment principle that the federal government has to treat states equally today. And so, what Minnesota and Illinois are arguing is that the federal government is not treating states equally today. It's targeting states like Minnesota and Illinois that didn't support Trump in the 2016 and 2024 elections, or the 2020 election for that matter. And in that way violating equal state sovereignty. And I think I'm not sure if this argument really has much traction. We'll just have to kind of wait and see how the courts rule on it. But I do expect that if it has any traction in these cases, we're going to see more and more of this equal state sovereignty idea in other cases where the Trump administration is specifically targeting states like Illinois or Minnesota or California or New York, blue states that Trump has put a target on, and treating very differently than states that support him. And so, Barb, if I could, I know there are some really good questions, but there were some earlier questions about the National Guard, and I just want to be sure that I touch on National Guard deployment and the potential Insurrection Act invocation that we heard from Trump today. If I can take just a second to talk about that.
Oh, yeah, I hope you brought your jammies because I don't think we're going to let you go right away.
So I'm happy to stay as long as anybody is. This is great stuff to talk about, and I'm really glad we're having this conversation. Um, so again, when Trump calls up the National Guard, our Constitution doesn't allow the president just to go around doing stuff. The president has to have statutory or constitutional authority to do that. It turns out there are a couple of different sources of authority for the president to call up the National Guard. When the president has done it so far in California, in Oregon, in Illinois, and other places around the country, he's used statutory authority under Title 10 of the United States Code. This authority is seldom used, kind of a novel use of it in the Trump administration. It allows the president to call up the National Guard when regular forces, and here I'm using the language of the statute, regular forces are unable to enforce the law in a jurisdiction. Trump made a determination in those jurisdictions is that regular forces were unable to enforce the law, and that therefore he could call up the National Guard to assist local law enforcement in enforcing the law. Not that National Guard would actually be enforcing the law, but that they would assist local law enforcement in enforcing the law with support services. The lower courts have largely said no, you can't do that. And in fact, courts here right in Chicago have said no, you can't do that. That's an invalid use of the statute. That case then now is at the Supreme Court, where the Trump administration brought an appeal, and the court's looking at a really interesting kind of piece of this case. What does regular forces mean? I think everybody up to this point, before the case got to the Supreme Court, thought regular forces meant, our local police, Chicago police, who are unable to enforce the law, according to Trump. And we may disagree with that assessment, but that we all agree that we're talking about Chicago police. Well, it turns out that might not be what we're talking about. Regular forces might mean the military forces, that the military forces are unable to force the law. And that's the trigger for this Title 10 statutory invocation and calling up the National Guard. And if the president has to show that the military is unable to enforce the law before he can invoke Title 10, well, that's a different ballgame entirely. The president is not able currently to show that the military is unable to enforce the law because he hasn't called up the military to enforce the law. And so there's a good possibility at the Supreme Court that the Trump administration will lose, a extremely rare loss at the Supreme Court, but nevertheless an important one, and foreclose Trump's ability to use this Title 10 statutory authority to deploy the National Guard. So if he can't use Title 10 and he is, ramping up enforcement by ICE in places like Minneapolis and causing all kinds of chaos and havoc in those locations, is there anything else he can do? Well, yeah, the Insurrection Act, what he mentioned today and what he's kind of been murmuring about since he got reelected. And even going back to his first term, murmuring about invocation of the Insurrection Act. The Insurrection Act authorizes the president to use the regular military or the National Guard or both, but the regular Army, Navy, Air Force, Marines, the president could use to enforce federal law if the president determines that there's a rebellion or insurrection or inability, generalized inability to enforce the law in a jurisdiction like Chicago or Minneapolis, for example. Now, the difference between the Insurrection Act and the Title 10 authority that I mentioned earlier is that under the Insurrection Act, the officers that are called into duty, the military officers, can enforce federal law directly. Remember, under Title 10, I told you that the National Guard would be supporting law enforcement. Under the Insurrection Act, they would be enforcing law themselves directly. And that's because yet another act called the Posse Comitatus Act doesn't apply to an Insurrection Act invocation. Now, the Insurrection Act has been used about 30 times in our country's history. Both Washington and Adams used it to suppress insurrections early on in the Republic. We saw Lincoln use it around the time of the Civil War. We saw right here in Chicago, we saw the president use the Insurrection Act to call up the military to quell the Pullman strike riots. We saw Presidents Eisenhower, Kennedy, and Johnson use it in the Civil Rights era to use federal military forces and National Guard to enforce Brown versus Board of Education and school desegregation in southern states that weren't desegregating their schools. And then most recently, we saw it used in 1992 in LA in the Rodney King riots. Now, in 1992, the governor asked the president to invoke the Insurrection Act. In the civil rights era, these were not with the governor's consent. The governor was opposing the invocation of the Insurrection Act. But we haven't seen any invocation of the Insurrection Act since 1992, and we haven't seen any invocation of the Insurrection Act since the Civil Rights era against the wishes of a governor or state legislature. And it looks like we're on the cusp of that now in 2026. It's pretty dramatic. I just want to kind of tell you very quickly what the Insurrection Act does not authorize. It does not authorize martial law. This isn't military law. It's simply the military enforcing already existing federal law, which is frightening enough. I understand that, but it's not a new set of martial law that is going to be implemented. That said, if President Trump invokes the Insurrection Act based on what we've seen by ICE agents and Border Patrol, other DHS agents, the FBI, and other agents that have been active in our cities, I would fully expect the military effectively to try to implement martial law in these jurisdictions, which is just a terrifying prospect in the United States. Um, I actually worry quite a bit that that's the direction that we're moving. What can be done about this? Well, we can talk to our members of Congress and try to get them to push back on any invocation of the Insurrection Act and even to amend the Insurrection Act if they're so willing and the politics line up for them. But Congress does have a role here, and And we understand that the House and the Senate are controlled by Republicans who are largely towing the line, but we are starting to see some fractures in the Trump MAGA support base in Congress, and this might be one of those areas where enough Republicans would be willing to peel off and go with Democrats to try to do something about the Insurrection Act if Trump were actually to invoke it. So kind of a ton of information in a short period of time. And Barb, I'm going to tell you as I'm going through all this stuff, this is what I've given this group in the matter of about 50 minutes total would have constituted, I think, a good 5 or 6 weeks of my constitutional law class. So kudos to you all. I appreciate that.
Well, there's not a test following this presentation, right? We're okay.
um,
S- So the one of the questions that I've gotten often is what allows these federal agents not to abide by what we all common people know as our constitutional rights? That of search and seizure, being picked off the street and with, requiring citizenship identification, arresting
yeah,
people without a warrant.
yeah.
How is that possible with our Constitution?
So, there ICE can violate our rights in a lot of different ways, and they have, right? We've talked about free speech. We've talked about violating free speech rights, free association rights, free press rights, religious rights. Barb, had mentioned warrants, and I know a question about warrants came up earlier. There is some authority that ICE agents have to temporarily detain somebody if they have reasonable suspicion that the person has violated the law, but otherwise they need a warrant based on probable cause to conduct a full arrest that the person has violated the law. And we're seeing ICE violate that all over the place. And I do just on this beat, on the warrant point, I want to give this group some information that I think is really important that you may not know. So there are two different kinds of warrants that we're seeing in immigration enforcement. One is an ordinary judicial warrant signed by a judge upon probable cause that a person has engaged in illegal behavior, in this case, an immigration violation of one sort or another. And an ICE agent would go and swear out an affidavit and get a warrant from a federal judge in the way that an ordinary law enforcement agent might do that if they wanted to seize somebody or search property, right? Um, and those are judicial warrants and they're fully valid, assuming that they've been sworn out properly and that they actually specify probable cause. But there's another kind of warrant that agents have been using. It's an administrative warrant issued internally by DHS and ICE that is not signed by a federal judge, but really looks quite official. And for somebody who doesn't know the difference between a judicial warrant and an administrative warrant, you could easily confuse an administrative warrant for a judicial warrant. And, given that a uniformed officer holding a gun is presenting you with an administrative warrant, you might be inclined to comply with it. There's no legal force to an administrative warrant, none whatsoever. It doesn't allow ICE officials to do anything. And yet they're using these all the time to engage in immigration enforcement sweeps and immigration enforcement arrests. And so I just want to, the warrant thing, I feel like is an important thing. I've been doing a lot of Know Your Rights talks in the Chicago area, and this is a theme that has come up repeatedly. And I just want this group to understand the difference between those two warrants and one of the clever ways that ICE officers are getting around the judicial warrant requirement. Having said all that, how are ICE agents getting away with this? Well, they're getting away with it because they have an administration that is supporting them and because of all the reasons that we talked about that make it so very difficult to enforce the Constitution against federal agents. It's just a really, really difficult thing to do. I'd mentioned earlier that there was this ruling um, last year, late last year, from a federal judge here in the Northern District in Illinois out of Chicago, over 100 pages detailing all the different violations from free speech to free association, free press, religion, all the different, with the warrant requirement, all the different violations that ICE officers have been engaging in here in Chicago, and then issuing an injunction against ICE, requiring them to take certain action to respect rights of individuals and to pull back on their more aggressive enforcement action. The appellate court restricted that injunction to some degree, and the case is now back at the district court. We were going to expect a ruling before too long from the district court to see if they can adjust that injunction. But the upshot here is that it's really, really difficult to get federal officers to come into line with the Constitution and federal law if their bosses and their superiors within the executive branch are unwilling to enforce federal law and unwilling to require them to comport with the Constitution and federal law, and if we have a court system in Congress that's unwilling to check them. It's really, really difficult.
But we've had this question come up several times in the chat. Is there nothing that Illinois municipal police can do if they see an ICE officer breaking an Illinois law or assaulting a person? I mean, that's not federal law, that's Illinois law, right? Is there anything
Exactly.
that they can do to that?
And that's, Barb, great question. And that's where we're seeing more and more discussion about criminal liability at the state level for federal officers, right? And again, they've got to show the illegality, the unreasonableness, acting beyond the scope of the duty, and some excessive force. Like you've got to show that the officer is clearly acting outside of the scope of their duty and beyond the Constitution. That's not always an easy thing to do. And it raises
So could a local policeman arrest an ICE officer if he sees them?
The answer is yes.
Yeah.
And let me
Because
give
there's
you an
confusion,
example.
I think, in that
I
the local
know.
police can't do anything to.
Exactly. Well, okay, so I'm going to give you two extremes, and
Okay.
then we're going to start to see the hard gray area in between.
Oh, great.
So, one extreme, assume that you have an ICE officer on the street, fully uniformed, fully identified. They don't have their gaiter on, they haven't changed their license plate, and they're fully engaged in lawful immigration enforcement that everybody concedes is lawful. And a federal officer tries to arrest them. That's not going to work, right? Or even if that agent maybe is speeding on the streets in Chicago in their vehicle because they're in hot pursuit of what they think is an unauthorized non-citizen, and an officer pulls them over for speeding, right? Well, they're engaged in their job. They're unlikely to be subject to prosecution in that case. On the other extreme, consider an ununiformed ICE agent who's not on the clock and they're speeding through the streets of Chicago in their private vehicle. Well, they can be arrested just like you and I can. The fact that they're a federal agent gives them no immunity from ordinary state law when they're acting outside of the scope of their job. Now, if you consider those two extremes, which I think, almost everybody would agree on, you can start to see the significant gray area in between. What if you have an ICE agent who is uniformed in a confusing way, without their badge, wearing a gaiter, changed their license plate, and engaging in constitutionally questionable enforcement actions, right? Or enforcement actions that kind of verge on illegality under Illinois law. Is that person acting within the scope of their employment? That's a much, much harder question. They're doing a lot of things that don't look like they're within the scope of their employment, but you can bet that this administration is going to argue hard that they are acting within the scope of their employment. And at that point, the courts are going to have to work it out. And that's kind of the tough issue that we're dealing with. And I got to tell you, so far, the Supreme Court, at least, has been highly deferential to the Trump administration on hard questions like that. it's basically rolled over and given the administration whatever it's wanted to on the so-called shadow docket. We can talk a little bit more about that in future sessions, but I would expect that the Supreme Court would behave similarly in a case like that. Again, we can arrest ICE agents. Their fact of federal employment doesn't give them categorical immunity if they're out off the clock engaged in illegal behavior. But what's going on really falls into a bigger gray area. I think is the way the courts would see it.
Yeah, because we just don't know what an ICE agent, typical ICE agent looks like because they're not uniformly dressed, right?
God. I mean, it's kind of hard to believe we're having this conversation, but that's the reality that we're in. And so, historically speaking, do ICE agents behave like this? Well, good grief, I hope not. And I would hope that we would think that somebody who has a confusing uniform or doesn't clearly identify them or wears a gaiter, that by itself means that they're acting outside of the scope of their employment. But in this new reality, I don't think so. I think the courts are likely to defer to the administration on questions like that.
We do have a quick question just to back up a few conversations. Do the warrants look different? You were talking about a
Mhm.
judicial warrant and an
They
administrative
do.
warrant. Do they look different?
They do. And I've actually got, if I can't put my hands on them really easily to share them with you, but I've got some examples that I've used in Know Your Rights sessions of an administrative warrant and a judicial warrant that are, sort of marked up so that you can see what the differences are. The big difference the between them is that a judicial warrant is signed by a judge, a federal judge, and an administrative warrant is not. That's the big difference. And so if you're presented with a warrant and you need to immediately determine is this a valid judicial warrant or is it an administrative warrant that carries no legal force, look for the signature of the judge on it, and it needs to identify clearly that that's a federal court judge. And if that signature is not on the docket, that is not, or I'm sorry, on the warrant, that is not an official judicial warrant.
Our time is up, and you have so graciously extended by a few minutes to answer some questions. I have about five more in my head, but I'll save those till next month. How's
You and
that?
me both, Barb. You and me
Yeah.
both.
Oh, I hope everyone can join me silently in applause and thanks, Steve, for this wonderful hour. And as we leave tonight's discussion, we all hope that you'll feel more confident in connecting what you see in the news with the principles of the Constitution, and that we're more empowered to engage in civic life. Steve has given us terrific suggestions if we want to make change in how to do it. Understanding this relationship is an ongoing journey. So, this is not a one-time session. We will be meeting each month on the third Thursday of the month at 7 o'clock on Zoom so we can talk about the issues that are in the news. So, we invite you to join us again on February 19th for our series where we will continue exploring current events through the constitutional lens. And we look forward to seeing you there. Once
And Barb,
again,
we're going to post this recording tonight and people can
yes.
look at it at their leisure as well and share it,
Right,
correct?
right. We will be posting this on the League of Women Voters of Wheaton website so that you can share the video with your friends. And we hope you'll share an invitation for them to join us in February. So thank you so much, Steve. As always, I've learned so much and I have more questions than when I started. So thank you. Thank you.
Thank you, Barb. Thanks, Chris. And thank you, everybody. It's been a real joy and honor to be with you. I appreciate it.
Thank you. Come with your questions next month. Good night now. Good
Good
night,
night.
Steve.